Chapter 26, Remedies for Breach of Sales Contracts. In Chapter 25, we looked at the buyer's and seller's duties and responsibilities under the contract. And we talked about how if one party fails to perform one of their parts, that's considered a breach of contract. So now we're going to look at what happens when someone breaches. What are our remedies? And typically when one thinks of remedies, they think of damages. The damages that one gets from a breach are typically thought of as money or some kind of recovery or fixing of the product to make the situation right. So in order to bring a lawsuit, the first part that a plaintiff has to think about is how long do I have from the time the breach occurs to when I bring my lawsuit. And there's a law that covers that, and it's called the statute of limitations. It puts a limit on the time that a plaintiff has to bring a lawsuit. The time limits to bring a lawsuit under the UCC is usually 4 years. So usually a plaintiff, and it could be the buyer or the seller, depending upon who breaches the contract, must file a lawsuit within 4 years of the time of the breach, that the breach occurred in the contract. Now this is really important because 4 years is actually longer than most common law claims. Any other lawsuit not occurring under the UCC typically only has 3 years in which to bring the lawsuit. So a plaintiff would oftentimes want to be able to find some breaches like of warranty or some sort of provision under the UCC in order to give themselves a little more time to bring their lawsuit. So let's look at what the remedies are for a seller. If the buyer breaches the sales contract, the seller has 5 remedies. The seller's lien, the remedy of stopping shipment, they can resell the products, they can cancel the delivery of the goods, or they can make an action for damages under the market price formula. When we think of damages, in other words, you're going to get money from the other party, and in this case, it would be from the buyer for breaching the contract. So let's look at each of these remedies. The first is the lien. We've talked about liens in several chapters. The seller can retain possession, i.e. keep the goods that the buyer has already ordered until the buyer actually pays for them. So if the breach is a failure of payment, the seller can keep the goods until the buyer pays for them. Essentially, the seller has a lien, which we've talked about. It's a legal interest in the goods. So even though the buyer has made the contract and those are technically their goods, if they haven't paid for them yet, the seller can keep them and then eventually resell them to someone else and still proceed against the buyer. Stop shipment. This is probably the easiest remedy for a seller to pursue. The seller can stop delivery of the goods to the buyer if the buyer breaches the contract before the goods are delivered. So if the goods have not been delivered to the buyer, the seller can just stop the shipment. And this can happen even in transport. Let's say Samsung has already delivered the goods to a carrier and they're en route to the buyer, but the buyer's form of payment fails. Like maybe they had put them on some sort of credit and the seller receives notification that the payment failed. They could actually contact the carrier and stop the shipment before it arrives. Remedies of the seller resale. In this instance, the seller may resell any goods it still holds when the buyer has breached the contract. So thinking about our first remedy about the lien, these two would often go hand in hand. If the buyer never pays for the goods, or the buyer failed to pay for the goods, or if the goods that the seller stopped shipment on, our second remedy, and they still have them, they could choose to then resell those goods to another buyer, which is known as a substitute buyer. Now, when selling these goods to the second or substitute buyer, the seller might not be able to get as much money for them as the original purchaser had agreed to pay. So if the substitute sale to the second buyer results in a loss to the seller may seek the difference between the cover price, the amount the substitute buyer paid, and the original contract price. So let's look at an example. This isn't that difficult. You're going to see it. So buyer 1 agrees to purchase 10 cases from seller. So again, this is Target. Target agrees to purchase 10 cases of goods from Samsung for $10,000. Their contract is the contract price. But buyer 1, Target, breaches the contract. The seller could then find another buyer, say Walmart, which would be the substitute buyer, who agrees to purchase the 10 cases of goods. But let's say the substitute buyer, Walmart, will only agree to pay $8,000 for those 10 cases of goods. The second contract, where buyer number 2 agrees to buy the goods that the original buyer, Target, was supposed to pay, is called the cover price. Like you're covering the loss of the original contract. When there's a difference in those prices, the seller can resell the goods to a substitute buyer, get money, here $8,000, and then still sue the original buyer, Target, for the difference, which would be, in this instance, $2,000. And that's called a resell, and then you're getting the difference between the contract price and the cover price. This allows the seller to be made whole. They get their $8,000 from the second buyer, and then they can sue the original buyer who breached the contract for the $2,000 difference, so that the seller comes out with the full $10,000 that they expected to make in the first place. Action for market price. What if the seller can't find a new buyer? There's no one willing to buy their products or to buy those particular products. They can't find a substitute buyer. Are they out of luck? No. Because the buyer number 1 breached the contract, even if the seller can't find anyone else to buy the goods, they can't resell the goods, they can make an action for market price. The seller will go out on the market and, well, let's look at our example. Buyer 1 agrees to purchase 10 cases of goods from the seller for $10,000. Again, that's the contract price. At the time the seller tendered the goods to the buyer, i.e. made them available, the goods are selling on the market for only $7,500. What does that mean? A lot of times contracts are made months, years in advance. So for instance, Target might have ordered the 10 cases of goods from Samsung in October of 2019, but the goods aren't due to be delivered until March 2020. In October 2019, Target agreed to pay $10,000 for those goods. But now, in March, because of the way the market has changed, nobody is willing to pay $10,000 for the goods. The market price for 10 cases of Samsung goods is now only $7,500. And that's one reason why the buyer might decide to breach the contract. They may decide, I don't want to pay the $10,000 that I agreed back in October, because now I could buy them from Motorola or some other company for only $7,500 because the market has changed. So that gives you a reason why a company might breach a contract, and also indicates why the seller might have a hard time finding a substitute buyer to pay what they wanted. So in this instance, the seller can still sue the buyer, but what they're going to sue for is the market price, the difference between what the market will pay for those goods right now, $7,500, and the contract price, $10,000. Thus, the seller would only recover $2,500. We'll talk more about these issues when we go through our questions during our live discussion. Finally, the seller could also recover for their incidental damages. What are incidental damages? These are costs that are outside of the original contract. Originally, the cases of goods were supposed to be $10,000. That's what the buyer had agreed to pay. But once the buyer breaches, the seller might have to spend additional money outside of that contract trying to resell the goods, trying to find a substitute buyer, trying to affect their lien, or pursuing any of their other remedies, which might include transportation costs, storage costs. They have to pay to store the goods in a warehouse until they find a substitute buyer. They might have to spend money searching for finding a substitute buyer. Any of these expenses that the seller incurs because of the buyer's breach, they can also make an action for those against the buyer, and they would call them incidental damages, and they would be in addition to the original contract price. Now let's look at the remedies that are available to the buyer in case it is the seller who has breached the contract. The first is rejection of improper tender, revocation of acceptance, market price recovery, cover price recovery, and finally, specific performance. Rejection. If the seller tenders goods that do not conform to the contract, the buyer has the right to reject the goods. We talked about this earlier. When the seller tenders the goods, the buyer has the right to inspect the goods. During their inspection, if they find anything that's wrong, per the perfect tender rule, they can reject the goods. So this is one of the most immediate remedies that the buyer can pursue, is just to reject the goods and have the seller to cure them. Revocation of acceptance. This is a remedy the buyer has available to him even after they've already accepted the goods. They may find that they want to take back, rescind, or revoke their acceptance. The buyer may revoke their acceptance of goods if they find a defect that substantially impairs the value of the contract, and that defect was not discoverable during the inspection. Recall that as soon as the seller tenders the goods to the buyer has the right to inspect. When they inspect the goods, if they find anything wrong, they can reject them under the perfect tender rule. However, if the goods are conforming, or at least appear to be conforming, the buyer must accept them. And sometimes buyers accept goods that look fine visually, and then once they actually have them, they find that the goods are defective in some substantial way. For instance, electronics, as we mentioned, you can't oftentimes find out that there are defects with electronics until you actually begin to use them. That's a defect that could be substantial and that would not be discoverable during an original inspection. The power or remedy of revocation allows a buyer to take back an acceptance of goods that they discover were defective after they've already taken them. You also may revoke an acceptance if a seller failed to cure a defect which the seller made them aware of after a reasonable time. Recall again that after an inspection, if a buyer finds that there is some defect in their goods, they have to allow the seller a time to cure the goods. If the seller never cures the goods and a reasonable time has passed, then the buyer can completely revoke their acceptance of that shipment, that order. Market price. If the seller fails to deliver the goods as required under the contract, the buyer is entitled to recover the difference between the market price at the time the buyer learned of the breach and the contract price. Now, what is this allowing the buyer to do? The market price recovery is set up for a situation where the goods that the buyer received are not conforming. They're not good. And at that time, they go out to purchase other ones. Well, at the time you learn of the breach, those same goods might be more expensive from another seller, from seller number 2. If that's the case, a market price recovery will allow the buyer to get some recovery from the original seller who breached the contract. Let's look at the example. Buyer agrees to purchase 10 cases of goods from the seller for $10,000. That's the contract price. The delivery date for the goods is March 26. On March 16th, the seller informed the buyer that he would not be able to perform under the contract. Notice that's an anticipatory breach because the seller's duty to deliver was not yet due, but he let the buyer know ahead of time that he would not be able to perform. That's an anticipatory breach. And this is a good place to do that because you're allowing the buyer to make other arrangements. If the buyer were to buy the 10 cases on the market on March 16th, she would have to pay $12,500 for the goods. The market price is now higher than when she originally entered the contract. So she can sue the seller for the difference between what she has to pay on the market, $12,500, and what she would have paid under the contract, $10,000. So what does this mean? She can get the $2,500 from the original seller that she's having to pay to get the goods from a substitute seller. So what this market price allows a buyer to do is if the seller breaches the contract and the buyer has to go buy the goods from another seller and pay more, they can sue the original seller for the additional money that they are having to pay. Specific performance. Specific performance is a very rarely used remedy that the buyer has at their disposal. In this instance, rather than seeking money, what the buyer wants is for the court to order the seller to give them the goods that were the subject of the contract. This isn't going to happen very often. You're only going to be able to get specific performance if the goods are rare, unique, or one of a kind. It's something that, in this instance, you're saying to the court, money isn't going to make me whole. I can't go and purchase what we agreed to from anyone else. I need the particular thing that we had agreed upon. For example, seller enters into contract with buyer to sell the buyer her rare Picasso painting for $2 million. The seller changes her mind and breaches the contract. The buyer might seek to have a court order specific performance, which is ordering the seller to hand over the specific thing that they had agreed to do, which is sell the rare painting to the buyer. Here, the buyer is going to argue, I don't want to keep my $2 million. Even if I find another painting that costs less than $2 million, it still won't be this particular rare Picasso. I want that painting and I can't get it from anyone else. This is the type of really special circumstance when you might be able to get a court to order that the other party actually turn over the thing that they agreed to. It's highly unusual, and you rarely get it, but it is one of the remedies that the buyer could pursue if they had the right situation. Finally, incidental damages. Just like the seller, a buyer may incur incidental damages in the instance when the seller has breached the contract. If the seller breaches the contract and the buyer spends time trying to find a substitute seller, someone else who has the goods, the buyer might be able to collect money for time spent, say, FedExing purchase orders around, or FedExing information about shipment, or they might be able to any money that they spent trying to find this substitute seller. They may have potentially lost profits during the time when they should have received the original goods and the time they're able to find substitute goods. Sometimes they can get lost profits and categorize those as incidental damages, or more specifically, consequential damages due to the loss. We will talk about how some of these incidental damages and how to calculate these during our class live discussion when we work the problems next week.